The Taxation Law Amendment Bill 1971, introduced in the last session of Parliament, which was before the Lok Sabha, was discussed, The bill sought to amend the Income Tax, Wealth Tax, and Gift Tax Acts, apparently with the objects of countering non-payments of tax through understatement of the value of immovable properties in the instruments of transfer, curbing the practice of holding of property in various names and appointment of a cadre of valuation officers for assessment of the value of different types of property. The board generally agreed that the bill should be opposed in principle. Shri K.R. Agarwal said that the bill will mainly hit those persons who put their transactions on paper. If the bill was enforced, there was ever possibility of transactions in property coming to a stand still. He further said that the bill had been loosely worded and legal loopholes had not been taken sufficient care of. There was no provision in the bill to counter the lowering of tenancy rate to bring down automatically the value of a property. Further, the Rent Act, read with the provisions of the bill, will create an artificial situation. The Rent Act was not applicable to government in exercise of the powers conferred by this bill. Advantage may be taken of this position to remove the tenants from the premises. He suggested a strict time limit, not exceeding 6 months, for government to make up its
Shri
mind
H.R.
if
Singh
it was keen to
expressed
take
the
over
view
property.
that the bill will only increase disputes over the fair market value of a property. If arrangements could be devised by which a fair valuation of an immovable property could be carried out before its transfer, this would bring down the number of disputes. Shri D.S. Gill pointed out that according to the bill, decisions of the component authorities were appealable to the Central Board of Direct Taxes, which was an administrative board. The appeal should appropriately lie with the High Court or Supreme Court, should be set up for hearing appeals. The committee should favor an independent court with the right of appeal to the Supreme Court. The members decided that comments on the bill should be submitted in the light of the views expressed by members, full stop. Emphasis should be on the undesirable effects which the bill will have if enforced and on the constitution of an independent court to decide disputed issue with right of appeal to the Supreme Court, full stop. On a suggestion from a member, it was also decided to suggest that the 15% which will be paid in addition to the amount of the apparent consideration of a property as acquisition compensation should be treated as capital receipt and not as part of the sale price. Full stop. The panel discussed a note received from Shri N.B. Captain of Statesman seeking clarification in regard to the amount of prerequisites which will be actually disallowed under section 40A(v) of the Income Tax Act, full stop. The unanimity of opinion was that the disallowance will be the total expenditure which the company has to bear beyond of the salary of an employee or rupees 1000, whichever is lower, full stop. It was decided that the member be informed accordingly, full stop.